This episode was sponsored by the Geopolitical Insight and Education Foundation. Want to find out more? Check the link in our show notes.
Welcome to another episode of Legal for Tech, the podcast. So guys, you do recognize my voice. It's always already here. And as I've said many times, this is just a group of students and young professionals who are very interested in anything that has to do with technology. And yes, it's regulation. And today I'm joined by my friend and colleague, Giacomo Di Gregorio. Hi, Jack. Great to see you.
Hi, Rossi. How are you?
All good. It's very warm here, incredibly so. But let me say another very hot topic that we are actually discussing today. It's a case that's been discussed before the CJEU. I'm pretty sure it was this Tuesday, very important day. And yeah, we're already talking about it. So how cool are we? And we are here to discuss it with a lawyer and a friend of the podcast and of course, myself. Great to see you, Micha Schimmel. Welcome on the podcast.
Thank you so much. Yeah, I'm really happy to be here, and I'm also a bit honored to come on your podcast and do this really hot topic of this judgment of last Tuesday. Yeah.
Yeah, for full disclosure for everyone that follows the podcast, Misha and I know each other because basically we've been collaborating through the law firm for which I work, and also Misha's law firm has been collaborating. We have had a client in common basically, and we also share some of the views and perspectives that are linked to the cases that we will be discussing. So just in case anyone want to check our work out, just let you know. But setting that aside, how you know me, Misha, how did you come through across this path, the path of law, litigation? You're obviously based in the Netherlands, but how did you come across this idea? Why did you choose to specialize in this field?
Well, it all started when my mother was pregnant with me, of course. No. Of course, I studied law, and then I had to choose my master's degree. And there was this presentation from some professors at the Free University in Amsterdam about IT and law. And the presentation was really good. And I started thinking about, well, this is something that's really interesting because technology and IT always changes, of course. That means you always have a new challenge to figure out. And that's the reason why I chose this field, which now is 14 years ago that I finished my master. And I got to work at this beautiful law firm in Amsterdam called Solve, which is really my happy place to be. And ever since then, I've been focusing on everything related to IT and privacy and technology.
So you've been literally basically working in this field since the very beginning. So you haven't tried any other sector of law and then fell in love for IT and technology. You went straight away.
I also did some corporate law as well during that period, but it's always been a combination. So when I did some corporate law, it was for IT clients, right? So
Sure.
you also have a background in corporate law, which I find comes in really handy in the collective redress cases that I'm doing. And basically, when the WANCA, the Collective Redress Act, came into force, we started working there as well as a law firm, and me and my colleagues as well. So for the past, I think, 6 years, that's been my main focus. So it's like 80% of my work is collective redress right now.
So you're the most expert in this field. We can say that. Now, we are not going to talk about specifically a case that has to do with collective redress, but we are going to talk about a case that potentially has a lot to do with the way that collective redress has been kind of viewed until now when it comes to IT and technology law and the field of litigation that you are obviously a specialist in. So this case is a joint case. It had been discussed before the CJEU as I said, on the 16th of June. That was last Tuesday. And very funnily and very importantly, it has a very funny name, which is called the Coyote case, which I think is absolutely great because one of the websites of the platforms that was included in the judgment and that was one of the defendants was indeed called Coyote System. The joint cases are C 188/24 and 190/24. And we see two kind of big concept being litigated in this case, the concept of liability exemption for platforms, and the concept of liability for platforms that have control over the algorithm, over the distribution of content, even if they do not publish or produce the content that users can visualize on the platform. So let's talk about the case. Firstly, it is a case that has to do with the French government in some case, right?
Correct.
Yeah, and there are also multiple defendants because it's a joint case. So, could you help us untangle all of this mixture of establishments, companies, governments? What's going on?
Yeah. So when you say it's like two main topics here, if you take a big step back, I would say there's just this one topic, because the big question is, of course, how can we regulate these platforms, right? What can we do to to regulate and to govern ourselves and to protect us from the neutrality of these platforms? And if you look at the e-commerce directive, there's like two main mechanisms which currently serve as a protection for platforms. One is the fact, like the home state principle, the fact that as a platform you can only be regulated by your own home state, and other member states have to respect your home state laws, and it cannot put on you like general regulations which fall within the so-called coordinated field. And this has to do with the principle that the home state should be the one to govern the member state. It has a duty actually to govern that service, and other member states cannot interfere, so to say. Looking at you, Ireland. The second thing is, of course, the liability exemptions in the Articles 12 through 14 in the e-commerce directive, and also the Article 15, which prevents not only other member states but also the home member state from putting on an intermediary service a general obligation to monitor or to find facts about unlawful content. So yes, those are two separate topics which are discussed within this judgment, but I also see them as one part of the bigger major issue question: how can we regulate platforms in an online connected world, right?
A very brilliant kind of opening to the discussion of the case. I would also add one, I'm sure that we will talk about this, but this case is also about a very important topic, which is child protection online, which also brings me to the possibility that this conversation may kind of hint to examples of child pornography. And so just be aware of it. If it upsets you, just skip forward and otherwise keep listening. Just saying. So child protection is very important. It's a topic that is very important across member states. And of course, the European Union sets kind of minimal standards also within the kind of e-commerce directive already at the time. It was obviously written and came to force in 2000, but still has some kind of referral to the concept of protection and of specific categories of users that have to be protected specifically, but also is a very national topic. So France specifically has very, very tough laws for anyone that hinders children and teenagers from having a safe experience online. And I would say this is also a very important topic, because the way that the directive is interpreted kind of goes hand in hand with the feeling of a state that obviously has its own rules, its own history, and also its own categorization of what should be protected and what shouldn't. So
and it's also, of course, like a cultural thing, right? And especially France, as you say, they are more protected maybe than my country, the Netherlands, has currently been.
Yeah, crazy, because one of the things that is also comes out in the case is that, for example, in France, it is a criminal act, so a criminal offense, the fact of creating and publishing, so making it available to the public, anything that has to do with child pornography. So this also plays a very important role when it comes to detection and prevention of the spreading of specific material, which is personal data, which is obviously illegal if you consider the child pornography obviously is illegal, but also has a specific kind of evaluation within the French society, which needs to be kind of talked about. Great. So having kind of merged from what the case is about, I would ask Jack to ask the question that we're all waiting for.
Yes, of course. Thank you, Rosie. I wanted to know about the Section 230, because many argue that the EU essentially imported the US model into the e-commerce directive, but in a more conditional, confusing way than the Section 230. From your perspective, in what sense did the EU copy the US approach to intermediary liability, and where did it go wrong?
Yeah. So taking a big step back, like 30 years in the past, when the internet was up and coming, of course, the big questions were: are these platforms, which existed even then, of course, in the form of a forum or what have you not, would they be liable if someone posts information on the forum which is, for example, a copyright infringement or is otherwise unlawful? In the US, now I'm not an expert on US law, but I do know this. This topic is governed by two separate pieces of legislation. One is in the DMCA, which basically says, let me get my notes, you should have a notice and takedown system for copyright infringement specifically. But otherwise, as an intermediary, you're good to go. So the DMCA says, when it comes to copyright, you have to have a notice and takedown system. And take action as soon as someone uses that system. So that's the DMCA. And the second part is Section 230, which is about your question, of course, which says an online intermediary will not be considered a publisher for the information that someone else posts online on their platform. Now, the Section 230 is not just a liability issue, but it's also a free speech angle to that, because Section 230 also includes a clause saying that you are allowed as a platform to moderate your own platform. Saying, well, it's your platform, you're allowed to moderate it, even if that means that you're impeding the free speech of your users, because it's your own platform. So I think even in 1995 or 1996, Bill Clinton signed that into law. And after that, the EU came into action as well. I think starting from 1998, the e-commerce directive was drafted. And the EU basically said, let's do both of those topics in one go, right? So let's combine the two things and just make one directive which includes this topic. And under the e-commerce directive, which will basically say you are not liable for the information that is posted on your platform, whether it's a copyright infringement, whether it's tortious or whatever, or maybe libelous, as long as you are a neutral intermediary. But when you obtain actual knowledge, then you should act. Then you should remove the information or block access. Now, back to your question, where did the EU go wrong there? Where did they copy their homework but made a mistake? It's because they never included the Good Samaritan clause, which is, of course, now in the DSA included, which allows a platform to moderate as long as it's for the good, right? So if you just have a moderator on your platform who in his work finds certain unlawful content and removes it, you should not lose your neutral status, of course, because otherwise it doesn't work. The e-commerce directive did not have that clause, and as a result, those platforms were advised by their lawyers, you should not moderate the information on your platform. And I'm really looking into the mirror as well here, because I did that as well. Because basically that's how the law worked, right? As long as you do not know about the unlawful nature of certain content, then you have no obligation to act. You can still be a neutral intermediary and be exempted from liability.
I find that very interesting, because I think also at the time that you like obviously the directive was kind of implemented into the European system. We are talking about, I mean, and for me that's really difficult to explain because I clearly do not remember it, but we are talking about a union that was not a union, and we're talking a Charter of Fundamental Rights which was not actually made like basically integrated in the treaties yet at the time. It was getting to there. We are still talking about talks of constitution, a European constitution. And it is important to remember that we do have some kind of conception of freedom of speech and of balance of rights when it comes to freedom of speech and kind of state ability to tamper that freedom of speech, that then it comes in the European Convention of Human Rights. So, which is a bigger kind of conversation. It's 47 states because Russia is a bit rogue lately. But did you know? Surprise. No, but of course, at the time, you know, we probably saw a European Union that was kind of staying a bit more at the limits, at the boundaries of its powers. And now we're seeing a much more present, a much more strong and kind of vocal European Union, which has a different type of voting system. I mean, 2007 has happened, 2009 have happened, and, you know, there's been a change in our trajectory.
Yeah, this is a really interesting point that you raise, and I never thought about it that way. But the perspective that back in those days, the EU wasn't that much about fundamental rights is, I think, factually correct. But if you look at the e-commerce directive, and if you look at Article 4, subsection 3, you can actually see like the basic 3-step test that is also included in all the charters of human rights, right? So they wrote into the e-commerce directive the protection that may or may not have been specifically there from an ECHR perspective.
Yeah,
really interesting. And I would argue that when in drafting the e-commerce directive, I mean, in the EU, it's always about two things, right? It's about the free movement of goods and services and people, like free movement. And on the other hand, also always has been about the protection of fundamental rights. And I think you can really read that in the e-commerce directive.
Yeah, no, absolutely. And of course, fundamental rights have been always very important to the European, to the concept of Europe that we had ever since, you know, the EC and everything. Yeah. Although, again, you know, case law also developed in a different way. There has been a very strong German influence on the conception of what a right is and how it is to be protected and to be balanced. And I think probably that hasn't come across in the directive as much as the system has been kind of implementing it and evolving in that direction. And we have seen it. I mean, 2026 is finally the year where fundamental rights in the EU are protected in a different way, are protected in a very vocal, in a very almost militant way from the CJEU, I would say.
Definitely, yeah.
And in this trajectory, since we've talking about history, I mean, look at us. No, but in this trajectory, I would say let's literally go for years. We started off in 2000, as we said, that's the directive when it was implemented. Then we have 2022, and that's a very important year because it is the year in which the European Union, through a number of other kind of mid-steps and in-betweens, but in 2022, the European Union finally comes out with the Digital Services Act, which is the regulation. It is a regulation, not a directive anymore. And it is the regulation that kind of brings platforms into understanding that they can be accountable for the actions that they kind of put through on the platform. If you have control, the growing level of control of online platforms on the content, on the recommendation systems, that brings responsibility within the European Union. And then we have 2026, and we have cases like Ras Media 2025, I think it was December, the 2nd of December, if I'm not mistaken. And then we have Coyote, 16th of June. Let's put these dates all together and kind of bring back the conversation to what kind of evolution there has been and what do you see happening in the sense of platform liability and literally provider liability when it comes to this year and this case.
Yes, so maybe just focusing on Coyote right now to start with. Of course, the main takeaway from Coyote is if you have an algorithm, then you have control over the information that is stored on your platform. Maybe that's a bit short, but that's the essence, right? So it's a big message to all the big tech platforms that you are no longer a neutral intermediary because your algorithm is for your own purpose, for your own good. You're not doing it to help your users, it's to make more money. That means you have control over the information stored, and you no longer have access to that liability exemption. So that's basically the main takeaway and the most important part of Coyote. What I find interesting after reading and rereading and rereading the judgment is how the CJEU points us back, even back to like Google France in what is 2010, 2011, saying we've been saying this from the start.
2012, I'm told by the
Yeah, very good. Yeah. We've been saying this from the start, and if you read the paragraphs and the referrals to Google France and read the paragraphs in Google France, they are literally saying in that same judgment, they are pointing to the same recital 42 in the e-commerce directive, saying if you have either knowledge or control, then you are no longer a neutral intermediary. So this was something that upon the first reading I missed, but after rereading, it's almost like the CJEU is shouting, we've been saying this all along. It's either knowledge or control, and not because we've been focusing on the knowledge part, right, in all those judgments. L'Oréal eBay and Google France, and even the YouTube Ciando ruling in 22, 23, what is it, was also about the knowledge part of the equation, but never about the control part. And this is where this judgment is earth-shaking, of course, because based on that control branch of the liability exemption, the court says, well, if you have an algorithm, you're in control of the information. So no, you don't have liability exemption.
Okay, so we have explained what the kind of case law that goes from kind of Google Spain, but also, I mean, through the various stages that then, yes, kind of brought it to the DSA, but also brought to the case law that and ultimately ended up in Coyote. Obviously, as I said, the DSA has this issue that it diversifies the type of platform that we have at our hand. So there is this concept of mere conduit, which is like literally just, I mean, content is passing by, I'm not doing anything with it. And I would say that this conceptualization is very much advocated for by little, smaller, and I'm obviously kind of making a joke out of it because they're not that small, but these systems such as Coyote, that say no, we haven't been doing anything. We're just like a very kind of basic neutral channel of passage. We're not really the station that then decides where the train goes, basically.
Yeah.
Do you think that like that conceptualization within the DSA has misled companies, or maybe brought them to the kind of to divert the problem rather than actually finding a solution? Or would you say that actually having something like the DSA is very useful, and we shouldn't think that such categorization is preventing people from being protected in this way?
So my advantage is that my perspective is a bit longer than just a DSA, of course, and it's been my experience that the liability exemption, which of course was already in the e-commerce directive, just has been used strategically by internet companies, right? So the way that they govern themselves and they make their business model has been based on the premise that they would not be liable for the content that's stored by the users anyway. So even before the DSA, companies such as Coyote Systems existed, of course, and built their platforms based around the premise that they would never be liable because it's not their content, right? And as long as they are just the storers of the information, like the the passive technical party to the party, they would be fine. Now, of course, the DSA did take some steps here, because the message of the DSA is via Article 34 and 35, via the other articles regulating the obligations that you have as an online platform, that your responsibility goes a lot farther than just providing your service. You have to make sure that in providing your service, you're not putting other people in danger. But that's mainly just a political message coming through via the DSA. But in practice, this decision from the CJEU has made it, like, with a megaphone, clear that, well, if you do something with the information for your own good, for your own purpose, then you can be liable. And there's, of course, a really good link to the Russ Media case that you already mentioned here. Because on the face of it, it has nothing to do with this case, right? Because it's like completely different legislation. That's about the DSA and about the GDPR. And this is about the e-commerce directive. But even in Russ Media, the CJEU explained that your obligation as a hosting provider, as a service provider, as an online platform, is not limited to what's in the DSA, right? You can still be liable under the GDPR, even if you do not publish the content yourself, even if it's user-generated content, because you are still a controller under the GDPR. And no, the DSA does not prevent you from liability there.
And I think both in Russ Media and obviously in Coyote, there's this kind of concept of TOMs, so technical and operational measures, which are present both in the GDPR and in the e-commerce directive. So you're kind of like bringing them to the same kind of level, regardless of what type of regulation or of legislation we're talking about. The point is, if the state has a right to impose specific obligations because there is a given exception that allows them to, then you have to put up with them and to kind of make sure that you're complying with them. And if you actually read, like, in the e-commerce directive, they do say, like, data protection law is one of the possible grounds for the state to impose additional obligation. And basically the additional obligation imposed by the state is one imposed by the entire European Union, and it is the GDPR. So the things are basically connected by this fil rouge of the way the TOMs are being used, and this view that TOMs also kind of include preventative measures. You should not publish the content in the first place. Pay attention to what you're publishing. So absolutely. And there's a whole connection there.
Interesting parallel there about how even in the e-commerce directive, the concept of data protection as a separate field was already there. So like the CJEU said in this case, it's always been there in recital 42. I mean, come on, read it, for God's sake. In Russ Media, you could say the same, right? It's already been there in the e-commerce directive that data protection was separate from platform liability.
Coming back to your area of interest and your profession, the Dutch VAMCA, did I say it correctly? I hope so.
Yes.
Model for collective redress. How do you think the Coyote judgment, with its more nuanced design and conduct-based understanding of intermediary liability, will play out in the Dutch context?
Yeah, interesting question. It takes away one defensive argument that we've always known that will come, right? Because the cases that we do against TikTok, against Snapchat, against Meta, and against X, they always have a content component to them, because these platforms are all about posting content. So take the TikTok case, for example, where our main argument is the addictive design of TikTok. We know that at some point the defense, TikTok is going to say, well, it's not our platform that's addictive, it's the content, of course, because, well, we can't help it if all these teenagers post funny videos of themselves dancing. And of course, that's the real addictive part of the platform, because the content is so fun, right? We always knew that was going to be one of the arguments that's going to be made. This judgment takes that away, because if, as a platform provider, you rank that content, and if you promote that content to a person, it doesn't mean you have knowledge of that information, but it does mean you have control of that information. So the liability exemption does not apply. So it takes away the argument about we're just a neutral, passive platform, and it's the user-generated content that's actually addictive. The same is true for our Snapchat case, which is also based on the claim that on Snapchat, it's way too easy to find drugs, illegal vapes, but also the fact that, I don't know if that's true in other countries as well, criminal gangs in the Netherlands are using Snapchat to recruit teenagers to do jobs for them, right? They are using the Snapchat interface for that. So they are posting like literal ads or shorts or spotlight videos, or I don't know what they call them at Snapchat, but in which they're simply advertising, you can do this job for us for like 500 euros. Before Tuesday, we knew Snapchat was going to say, well, we can't fight that. Look at all the things that we're doing in trying to prevent that. So this goes back to your Tom's argument, Rosie. The argument also would have been, we're taking so many measures to try to prevent this kind of behavior, but we can't do everything, right? That argument is out of the window.
There's this concept of like being effective. It's not just, oh, well, I'm putting up any measure. I think the DSA also takes up a bit of the same concept when you look at the risk management obligation, so 34 and 35 DSA. I've had a lot of time with Through Legal reading all the risk management prospects published by specifically Meta. I think starting 2022, but then they do the quarterly one. They're very precise with content. And yeah, we've been starting campaigns to help the public understand that this kind of content is not good for them and stuff. Yes, there are the existence of measures that do not mean that you're doing the right thing. And compliance does not just mean putting up some level of obstacles. Compliance means preventing something, if that's what the law says. The concept of compliance is not a range of possibility. Sometimes compliance is just one thing. You're yes or no. It can be binary. Not every time, but in this case, some laws, like the French one, it says it's a binary law. If you publish this, you will be liable. It's not, well, we are going to see how much effort you make. No, it's not a range. It's an actual yes/no kind of situation.
Yeah, because the claim is different, right? It's no longer about like an Article 34, 35 DSA question, whether you have done enough to prevent this. I mean, that's one part of it. But the second part of it is you are now primarily liable for the unlawful content that's posted on your platform. And that's like the main distinction. So there's a whole new avenue of attack here that just came available, to claimants.
Yeah, and going back to the very interesting topic of Snapchat, which I think is it your latest kind of claim? Yeah, it's a very interesting topic, Snapchat, because I feel like many don't see how Snapchat is being used. It is kind of portrayed as very much as a messaging app, a bit like WhatsApp, a bit like Telegram. And the three of them have serious problems because they've created an area of interaction that is not just with the people within the contact list, but it's kind of going far beyond. It's a social network, exactly like the other ones. But because it started off as, at least I would say probably parents view it as something that their children use to chat with their friends. They don't understand that they're not all friends.
Right?
Exactly. And I think Snapchat is very much like it's always overlooked in being this kind of like connection platform where literally it's very easy to add people randomly. And actually, I think people don't understand that like Snapchat allows you to have a public profile by definition, which
Yeah.
I think is unbelievable.
Yeah.
And you can decide what content gets published to the public, but technically, I would say if I were 14 or 13, I would probably want to appear cool. And if an
Right.
app is prompting me to make things public because I look so cool, probably I'm not gonna kind of retract and say, well, actually, I don't feel that cool.
Yeah,
I don't,
yeah,
sorry.
there's so much to unpack here, and specifically about Snapchat. Of course, the DSA has this concept of a very large online platform, and additional obligations apply to very large online platforms. Snapchat is a very large online platform, right? But the way that Snapchat has fulfilled those obligations under Article 34 and 35, they are based on the premise that their interpersonal communication part of their service is not in scope, which to some degree is true, right? Because a messaging service is not an online platform. So that's part one. Most of the criminal activity and the unlawful activity that we're focused on with that third pillar is actually occurs, of course, in the interpersonal communication services, like dealers offering their services in a private message to someone that they're connected with. So that's out of scope. But the point is that these criminals and these people who post this unlawful content, they are using the other features of Snapchat which are within scope to advertise their services. So they are posting spotlight videos. They are findable via the Find My Friends portion of Snapchat, which are all services which are or should be in scope of the DSA. And Snap did not take any measures, or they're not doing enough to prevent criminals from using the in-scope services to get to people via the out-of-scope services. You get what I'm saying?
Yeah, no, absolutely. And I think people really don't realize, like, if you are in Snapchat and just read the comments through the videos, you just scroll through, everyone goes like, add this. So yeah, maybe it's not that easy to get in touch with the person, but at the same time, if you just ask them to please add you, and it's so easy to ask them to add you, the function of the messaging platform is basically being used to be a social platform. And so yeah, there's always the distinction. Also on WhatsApp is the same. You have WhatsApp groups, and they're a huge driver of criminality. But the groups are kind of included in the obligations of the DSA, but the messaging that comes afterwards obviously isn't. So
No,
you always
exactly.
have this big question, like, if the group is helping me basically doing something illegal, why should it be excluded from actually, complying with the law?
Yeah,
So
to make it
yeah,
like really concrete, and maybe a trigger warning for child porn or grooming and what have you not. If a groomer contacts a minor via Snapchat, via the private messaging service, then based on the DSA, that is out of scope. There's nothing that Snapchat has to do to prevent that. But if that same groomer has used Snapchat in services like Spotlight or posting videos to friends of friends, right, which is no longer interpersonal communication, but it's communication to a public because you don't know who those friends are. If you use those services to get into contact with a minor as a groomer, then of course that's within scope, and Snapchat should do something about it.
and also I think, and probably you know more about this than I do, the use of artificial intelligence and all of this is also very important, because earlier on, a groomer would probably try and lure in a younger person, maybe having to use another young person, making videos and stuff. But like Snapchat is full of AI slop. And I think people don't really realize it. It's older people deploying fake AI personas to kind of lure people in, especially when it comes to sexual content. And obviously, you have no clue who's on the other side of the phone. But maybe like I'm just putting myself in the position of a 14-year-old. It is really not easy to detect the difference between an actual OnlyFans profile, for example, and a fake one, and an AI created one that has the purpose of asking you to send pictures and then using those pictures to actually kind of threaten you and make you do things that you don't want to do.
Yeah,
So
exactly.
it's, the use of AI is also something that should be kind of worked with within Snapchat, because although the obligations of the AI Act are still not into force, the fact that this kind of use is leading to illegal activity, again, should be viewed as a risk and not just as a, oh, well, people are just having fun on Snapchat.
Yeah.
Because, yeah,
Yeah, no,
very interesting.
100%. Yeah, definitely. Yeah.
It's very, very interesting. And I'm going to ask you one last question, which I think is super important. But we have discussed a bit what the effect and impact of Coyote could be when we talk about the VAMCA kind of regime. But if you actually have to look into the future and go like, okay, I'm waiting for this to happen. This is my greatest hope. And maybe also what you are afraid of, like what kind of interpretation this can lead to. Would you like, can you make an assessment of the future looks and how this case has placed itself and where you see the Dutch system being led to?
Yeah. So this battle is won, but the war is not over, right? Because the only thing that changes is the battlefield. And what I mean by that is we can now predict what the next line of defense is going to be based on this judgment. And I think the next line of defense is going to be, oh, well, but our algorithm, it's in your best interest as well, because it only gives you content that you want to see. And it's not in our interest to determine what information you see and when you see that information. It's for you. Or maybe it's going to be, well, we also offer an alternative to this algorithm, right? You can also use our chronological feed. We're pushing the algorithm, but you can use the chronological feed if you want. You didn't do that as a user, and it's your fault that you saw all this information. So that's going to be the next battlefield, I would say. Yeah. And in terms of what are my hopes or fears in the WAMCA cases, it's about the delays, right? So in the Netherlands, so far it's been taking 3, 4, 5 years to get a case to the substantive matter of it, which is, on the one part, it's something that we could have expected because it's new legislation and the courts really want to cross their T's and dot their I's to make sure that all the fundamental questions that need to be addressed are answered as soon as they can. Because the alternative, of course, if you skip over them now, then it's going to come back and bite you in the ass in a couple of years. So maybe that's the court's perspective, saying, okay, we're going to be really rigorous in testing the admissibility of these foundations, and so that we are sure that any judgment that comes out of this is going to be rock solid. That's a positive framing. Of course, the negative framing is, we discussed this yesterday, of course, that every year of delay is another year of teenagers being exposed to this kind of content and being exposed to AI slop and having their mind degraded because of the dopamine hit that they're being fed by big tech, right? The damage is real. And the delays are causing just way more damages than could have been.
Yes, and that's a brilliant point. I think kind of end up with, it's like, the thing that people don't see is that law is actually causing the delays in law are actually causing a very, very kind of real effect that is not anymore between two parties. When you had like contractual litigation, maybe like 100 years ago, you would see these two parties probably being blocked in doing anything they wanted, maybe with a good or something.
Yeah.
But it was between the two parties. And when you see, terrible when it happens in criminal law, of course, the delay. Giacomo and I are Italian, so we know what we're talking about when I say delay. But, it's this idea that, as much as a person's life is hanging on a cliff, basically, it's still one person, still a number of person, a very conscribed number of individuals. But when you talk about social media litigation and what you do at Solve, we are talking about millions, billions of people. I mean, a lot of Dutch teenagers, and it's crazy to think that their lives are also being maybe not. We're not talking about a life danger, maybe in some cases, but we are talking definitely about a right to grow up in a safe,
environment. Yeah, even on that.
yeah, like an actual right to be a child, which is being deprived of them because I mean, I've been seeing 12-year-old kids on Snapchat doing sexual content and stuff, and that's really sad. I mean, it's
It is,
just
yeah.
sad on a variety of levels.
Yeah, but of course, it's really good to know that I posted yesterday on LinkedIn. We're going to Luxembourg anyway with some of these cases, but it's really good to know that the CJEU has got our back, right? So they are all about fundamental rights, and Tuesday's judgment also confirmed that a specific age verification tool to be imposed on a specific provider is perfectly fine. You can do that, member states. Please do it now, because the court has confirmed that it's necessary. It can be proportionate to the purpose of public interest. It's okay to do that. Now is the moment to do it.
Yeah, I love that. Now is the moment to do that. Maybe if I can just conclude this conversation this way. As I said, Micha and I have been kind of collaborating with a specific NGO. It's an organization that takes care of the rights of younger people in the online space as well. It's called SOMI. I'm gonna literally butcher the name in Dutch, but I think it's Stichting Onderzoek Marktinformatie. Is that right? Is it really bad? Okay, thank you. But you can find the claims that Micha was talking about also on their website if you want to learn more. I think it's quite nice to go check them out, and we will put the link in our show notes so that you know the Snapchat case, the Meta case, both in the Netherlands, in Germany. I think there's something in Denmark as well. You can find out more about it because it's a good cause. I would say it's nice to bring the word around. Yeah, so I'm gonna thank you so much, Micha, for coming to the podcast today. It's been lovely to talk to you on this very warm Friday morning. So thank you so much for joining us and helping us understand the Coyote case. That was amazing.
Thanks for having me. It's been a blast. I really liked it.
Thank you so much. And thank you, Giacomo, for helping us and understand also the international implications of this case. Thank you so much.
Thank you both.
Thank you.
Thank you. This was all from Legal for Tech, the podcast.
This episode was brought to you in partnership with DG Beetle. DG Beetle helps privacy professionals to stay up to date with the most important European documents in the AI, data and digital space every day. Curious to know more? Check out the link in our show notes.